Hey everyone and welcome. Today, we're going to talk about something that's right at the heart of contract law. It's the absolute cornerstone, consideration. You see, without it, a promise is, well, it's just words. But with it, that same promise can turn into a legally binding contract. So let's get right into it.
And to really get a grip on how this all works, we're going to walk through the cases that every law student absolutely has to know. Seriously, these decisions are the building blocks of the whole doctrine. And by the end of this, you'll see exactly how they all slot together.
So here's our game plan. We'll kick things off with the basics, the price of a promise. Then we'll get into the nitty-gritty with the rules for valid consideration. After that, we tackle the really tricky, pre-existing duty rule, see how the courts got a bit more modern with finding a practical benefit, and we'll finish up with the get-out-of-jail-free card, the promissory estoppel shield.
Okay, first things first. Before we can jump into all the weird exceptions and complex stuff, we have to get our heads around the core idea. What in the world is consideration?
Let's think about it like this. If I promise to give you my laptop, what's the price you have to pay to make me stick to that promise? And spoiler alert, it isn't always about cold, hard cash. That price is what lawyers call consideration.
Right, so here's the classic, fancy legal definition from way back in 1875 in Curry v. Misa. I know, it's a bit of a mouthful, isn't it? But all it's really saying is that for a contract to work, it has to be a two-way street. Each person has to get some kind of benefit or give something up, some kind of detriment. It's the original this for that.
Okay, so we know it's about a benefit or a detriment. But you can probably guess that people have tried to argue that all sorts of weird things should count as consideration. So over the years, the courts have had to lay down some ground rules for what's valid and what's not. And rule number one is a big one. As a general principle, if I do something for you and only afterward you promise to pay me for it, that promise is usually worthless in the eyes of the law. Why? Because the price was in the past. You can't buy a fresh promise with a stale act. But, you guessed it, there's always an exception.
And here it is, from a case that's literally hundreds of years old, Lampley v. Braithwaite. It set up this three-part test. The court said a later promise to pay is binding if the act was done at your request, and we both kind of knew it wasn't just a free favor, and the payment would have been totally legal if you'd promised it from the start. It basically means we had an unspoken bargain all along.
Now, this next rule is absolutely crucial. It really gets to the idea of freedom of contract. The courts don't really care if you made a terrible deal. As long as the thing you offered has some value in the eyes of the law, we call that sufficient. It doesn't matter one bit if it wasn't a fair market price or adequate.
But there are limits, and White v. Blowett shows us exactly where they are. Here, a son promised he'd stop whining to his dad about the will. In exchange, the dad promised to forget a debt. The court said, nope. Why? Because the son had no legal right to complain in the first place. Giving up something you're not entitled to do is basically giving up nothing at all. It's got to be something real.
Okay, let's wade into some deeper water now. This is one of the trickiest parts of consideration, the pre-existing duty rule. What happens if you promise to give me extra money for doing something that I was already supposed to do anyway?
Well, let's look at public duty first. In Glassbrook Bros, a coal mine wanted extra police protection during a strike, more than the police thought was necessary. The police agreed to provide the extra officers, but for a price. The court decided that since the police went above and beyond their normal public duty, that extra service was fresh, valid consideration for the mine's promise to pay.
The story changes, though, when the duty comes from a contract. The classic old-school case is Stilk v. Myrick. Two sailors bailed on their ship mid-voyage. The captain, probably desperate, promised the rest of the crew extra wages to get the ship home. The court said, no deal. The sailors were already contractually bound to do whatever it took to get the ship home safely. They didn't provide anything new for that extra pay.
So for almost 200 years, that harsh rule from Stilk v. Merrick was the final word. But the world of business changed, and the courts started to realize that sometimes just getting a job done without any drama provides a real, tangible benefit, and that led to a massive shift in the law.
And this slide just lays out the battle perfectly. On the left, the old champion, Stilk v. Mark. On the right, the modern challenger, Williams v. Raffy Bros from 1991. Here, a contractor promised a carpenter extra money to finish on time, mostly because the contractor themselves would get hit with a penalty if the project was late. The court said that even though the carpenter was just doing his job, the contractor got a clear, practical benefit They avoided the penalty and the headache of finding someone new. And that practical benefit, the court said, was good enough consideration.
All right, let's get to our final topic. And this one is a bit of a curveball because it's not really a rule of consideration. It's a doctrine from a whole different area of law called equity. It asks the question, what if there's no consideration, but it would just be plain unfair to let someone go back on their promise? And no one says it better than the legal legend Lord Denning. This quote gets right to the point of promissory estoppel. It's about fairness. It basically stops a person from breaking a promise that someone else has relied on. And the case everyone learns is high trees. During World War II, a landlord agreed to slash the rent for a block of flats because no one could rent them. After the war, he tried to claim all the back rent. The court said, not so fast, the tenants had relied on his promise. But, and this part is so important, that doctrine can only be used as a shield to defend yourself. It's not a sword you can use to sue someone.
And this stuff is not just dusty old law. I mean, very recently, the Supreme Court in MWB v. Rock Advertising was dealing with the exact tension between that practical benefit idea from Rafi and the other old rule that just paying part of a debt can't be good consideration. It just goes to show you these questions are still very much alive and being argued about today.
So, that leaves us with this big question. In our modern economy, are the old, rigid rules of consideration really up to the job anymore? Or are these more flexible ideas, like practical benefit and basic fairness, the real future of how we decide which promises should be legally binding? It's a debate that's far from over. Thanks for watching.